Welcome to Sarah Mayhew's Employment Law Practice. This video discusses a guide to understanding unfair dismissal. It provides an overview of the employment law dismissal procedures for employers and their employees. From an employer's point of view, it outlines the procedures to follow when dismissing an employee. Following these procedures minimizes the risk of an unfair dismissal claim against you and the company. From an employee's point of view, it also shows what you should expect from your employer in the form of treatment and the procedures to be followed when being dismissed from your position within the company. In order to make an unfair dismissal claim, you must have been employed under a contract of service, i.e. as an employee, have been employed continuously for a 12-month period, and have been dismissed. A dismissal is said to have occurred if your employee terminates the relationship for whatever reason, or when a fixed-term contract comes to an end without being renewed, or when you, the employee, terminates the contract and is constructively dismissed. In general, if your employment is terminated in the first year, you, the employee, cannot bring a claim for unfair dismissal. However, there are some exceptions to this rule. A year's service is not required where the dismissal was for any of the following reasons: pregnancy or childbirth, maternity, adoption, paternity or parental leave, or time off to care for your dependents. A year's service is also not required where the dismissal was for any of the following reasons: where you, the employee, made a protected whistleblowing disclosure, or when you asserted that certain of your statutory rights had been infringed, or when you had tried to exercise your rights to make a flexible working request. Similarly, a year's service is also not required in certain national minimum wage cases, or health and safety cases, or certain shop workers who refuse Sunday work, and certain working time cases too, and especially jury service. This video only lists the more common exceptions. If you feel that your particular circumstances are not included here, call Sarah Mayhew on 01752 204 192 or call her mobile 0771 7346 204 for further help. If you have been dismissed from your position within your employment, your employer must be able to show a potentially fair reason for your dismissal. A selection of potentially fair reasons for dismissal is shown below: capability and performance, conduct, retirement, redundancy, statutory restrictions, and some other substantial reasons. If your employer fails to show a potentially fair reason for your dismissal, it will be deemed to be unfair. However, if your employer does show a potentially fair reason, the tribunal will then consider whether it was in fact fair. At this stage, all the circumstances will be taken into account. If the reason for your dismissal was medical incapability, your employer will be expected to have at least consulted you regarding your circumstances. and obtained medical advice as to your limitations, prognosis, and any adjustments. Your employer must also have looked at alternatives to dismissal in consultation with you, the employee, and your medical advisors. He must also have convened a fair hearing to consider your dismissal. Your employer must also offer you, the employee, the right to appeal against the decision to dismiss you. If the reason for your dismissal is performance related, your employer would be expected to have notified you, the employee, of your shortcomings. He must also give you an opportunity to improve over a reasonable period of time, and provided any reasonable support. He must also provide feedback as to your progress or lack of improvement. If your performance does not improve, your employer would also be expected to have issued warnings as to the consequence of your continued poor performance. The warnings issued are usually in the form of a verbal warning, and then a written warning, followed by a final written warning, followed by dismissal, if appropriate. For performance incapability, your employer would also be expected to have considered alternatives to dismissal in consultation with you, the employee, convened a fair hearing to consider your dismissal, and offered you the right of appeal. As an employee, if the reason for your dismissal is misconduct, you, the employee, must be informed in writing of the allegations against you. You must also be told in advance of the level of misconduct, and in particular, if dismissal is a possibility. You, the employee, must be provided with copies of the evidence against you. You should have a reasonable time to prepare before a disciplinary hearing, and there should be a fair and impartial disciplinary hearing at which you, the employee, may be accompanied. You must have a reasonable opportunity to present your case in your defence to the allegations. There should be a fair and impartial appeal process. As an employer, you must be aware of and follow the ACAS Code of Conduct when dealing with potential dismissals or grievances. Note that employment tribunals will take the code into account in deciding if a dismissal is fair. If an employer dismisses in breach of the code, the compensation may be increased by up to 25%. There is a wide category of reasons for dismissal which are not covered elsewhere, and they include a business reorganization, for example, or a restructuring which does not amount to a redundancy, or even a breakdown in working relationships. Some other substantial reasons include personality clashes, loss of trust and confidence, pressure to dismiss from a third party. Redundancy applies where the employer's requirements for employees to do work of a particular kind has ceased or diminished, or is likely to do so. Note, there can be a redundancy situation even when the employer is expanding or increasing the number of staff. This will normally require the following actions: a reasonable decision as to who should be in the pool for consideration for redundancy, and a fair method of selecting individuals for redundancy from that pool, i.e. a fair and objective criteria and a reasonable application of the criteria to the individuals. There must also be proper consultation with affected employees throughout the process, and consideration of alternative employment, where possible. A fair hearing and appeal process must always be in place. Note that where there is a potential for alternative employment, there are certain statutory provisions for trial periods and training, etc., which must be followed, and only those employees with 2 years of service or more are entitled to redundancy. Certain redundancy types are automatically unfair. Employees on maternity leave have a special level of protection and must be given preference if there is a suitable alternative employment available. When dismissing an employee who is subject to a statutory restriction that affects their performance, as an employer you are required to show that the statutory restriction affects the work that the person was employed to perform and that no alternative employment was available. Examples of this are where a salesman loses his driver's license, or a worker is not allowed to work due to their immigration status. When dealing with retirement, we now have new provisions which apply when a person has reached retirement age. Remember, the default retirement age is now 65 for both sexes. As an employer, it is no longer possible to automatically retire an employee just because they have reached the retirement age of 65. This video describes the basic guidelines associated with the dismissal of an employee. For a more in-depth understanding and guidance, please call Sarah Mayhew on 01752 204 192 or mobile 07717 346 204.